Hi, my name is Michael Lueder, and I am a labor and employment lawyer based in Milwaukee, Wisconsin. I have been practicing labor and employment law for about 38 years, and in the last few years, I've taken up representing pilots in claims against either their union, their airline, and sometimes against the FAA. My cases usually center around a violation of AIR21 statute, which is a whistleblower protection statute, the Americans with Disabilities Act, which comes up quite frequently particularly in the HIMSS program context, and then finally sometimes claims against the FAA itself for failure to issue an unrestricted medical or a special issuance. Today I'd like to talk to you about the AIR21 statute. This statute has been around not a huge amount of time, but maybe 20 years or something like that. Actually, I guess it's probably more like 25 years. It was passed in 2000, I think. The AIR21 statute is designed to protect mechanics, flight attendants, pilots who make safety complaints to their airlines, to the FAA, or complain about some failure to follow a federal aviation regulation. Today, I'd like to talk about that statute. I'll talk about others in times ahead. But I want to cover what I would consider 10 tips for someone who wants to bring a whistleblower complaint under AIR21 or really any statute. The AIR21 statute is, I think, well described in another YouTube video put out by a guy named Lee Seaham, a lawyer out in New York, White Plains, New York. And in that podcast, he goes through and he lists kind of the elements of a claim. I'd like to talk more in this case about how you set yourself up to make a complaint and how to best protect yourself. First of all, number one is AIR21 exists, and you should be aware that it exists. It provides that a pilot, a mechanic, a flight attendant, and the like can make complaints, that when they see a problem, they can say something, and the employer must not retaliate against them because they made those complaints. So that's kind of the overarching theme here, is that you're protected if you make a whistleblower complaint. If you see a problem, here's what you should do is document, like we hear so often in the legal context. When you witness a problem, you should clearly describe what it was that happened. What's the safety violation? Who is involved? List everybody involved. I'm talking about your own personal notes. Where are the documents? Are there any documents related to this? Do you take pictures? What are the potential consequences of the failure or the safety violation? You have that all down, and that's your first capture, right? You're trying to just gather any information, any documents, and you date the document that you're creating this from so that you can give a good report about what happened. The next thing to do is to consider and balance the risks. So this would be like the third step. What are the risks of presenting a safety complaint? I can tell you from some experience that the airline itself seems primarily interested in on-time departures and gathering as many customers as possible and getting as many of them on a plane. It's really the pilot, it's really the flight attendant, the mechanic, in my view, that is really responsible for airline safety. And the general public really counts on you to make sure that it is safe in the air. There are downsides, obviously, to making safety complaints. Some of the downsides could include retaliation, and retaliation could come in many forms. It could be the loss of some kind of job benefit or privilege. It could be termination. It could be a demotion. Now, all these things aren't just nakedly done. Usually the company will come up with some kind of what I would call a pretext for taking that action against you. But you should be aware of those possibilities. However, if you decide to make a whistleblower complaint, you should find this is number 4, find your company's whistleblower policy, follow the policy, follow the official channels, document, be clear and concise, be honest, straightforward, factual, review the company handbook, review any policies it has about whistleblower complaints, and make sure you follow them. Sometimes the companies will allow you to be anonymous when you make a whistleblower complaint. I will warn you, though, that if you make an anonymous complaint, you will probably lose the protections of the AIR21 statute, because it's very easy for the employer to say, in response to a claim you might make saying you were retaliated against, and say, we didn't know who made the complaint. You can't say that we acted based on the fact that Joe made the complaint when we didn't know that Joe was the one that made it. And oftentimes they do know, but they're not going to tell you they knew. So that is a pretty solid defense that an airline has to a whistleblower complaint, is that you made it anonymously and they didn't know about it. So how do we fix that problem? If you know you're going to make a whistleblower complaint, it's important you've decided I'm going to take the risk of retaliation. You need to make sure that everybody up and down the supervisory chain knows that you made that complaint. We've had clients who will copy 30 people on the complaint to make sure it's well known. Simply going to the app and making FSAP complaint or ASAP complaint online doesn't broadcast it to the world. You want the HR to know, you want the safety people to know. If you're called up on some disciplinary proceeding, you want to make everybody aware in that disciplinary process that you had made the safety complaint. Let human resources know. And this is all to avoid this employer common defense. You can also file, number 6, you can also file a complaint with the FAA. That's a safety complaint, and you're equally protected there. As long as the employer knows, you got to make sure the employer knows. Number 6 is, if you do receive retaliation or believe that you've been retaliated against, the most important thing, if you get anything from this whole podcast, is you must file your complaint within 90 days of the adverse job action. This is a great statute. It's not hard to prove cases under the statute, but we often are confronted with people who had the job action happen more than 90 days ago. And if that is true, you can't take advantage of the AIR21 procedure. So you want to be on top of the timeline. You want to file, although it seems counterintuitive, possibly, that you don't file it with the FAA. You can file it with the FAA, but the proper place to file is with OSHA, the Occupational Safety and Health Administration of the Department of Labor. OSHA is the one that receives AIR21 complaints. OSHA is the one that receives Sarbanes-Oxley complaints, and lots of different whistleblower protection statutes direct you to OSHA to file the complaint, and that's where you file yours. Number 8, seek legal assistance if necessary. 1, to make sure you stay on the timeline and get the complaint filed in the right place. And 2, to make sure that you're developing a strategy to best preserve your claims and to best make your case. 9 is maintain professionalism. You always, through the process, you're succinct, you're polite, you keep out emotion. State the facts, just the facts. Maintaining that professionalism will help later, especially if the communications that you're making are in writing, because I always think whenever I write something related to, some situation or problem, how is this read to a jury, right? Is this gonna, if I'm mad at the Home Depot because they've done something wrong, I don't just pop off. I'm thoughtful, businesslike in what I would say to them. In case someday you end up in litigation, you have to deal with your prior communications, then maybe they don't look so good. So be careful with that. And then I would say last thing, step 10 is prepare for the long haul. My clients are always amazed by how long litigation takes. It's sometimes years. If I start a case in 21, I might not see a result until 24 or 25, 26 sometimes. I tried a case in January of 23, and we're still waiting for the written decision from the administrative law judge 2.5 years later. So sometimes these things take a long time. Sometimes families get impatient. sometimes you will feel like you're being left out of things at work. It's a lot of risk to be a whistleblower, but it's really important because really you all are the stopgap between compliance and, in some cases, tragedy. So I look forward to doing this again. Hopefully it'll all continue to go successfully, and we'll talk about other things on future dates. Thank you so much.